Thank you. Good morning. Today is Monday, May 19th, 2025. This is the regularly scheduled Tennessee Auctioneer Commission meeting. My name is Roxana Gumucio. I'm the Executive Director with the Commission. As the first order of business, I'm going to go ahead and take roll call vote to make sure that we have quorum, and then we will proceed with our first item. When I call your name, members, if you can please turn your mic on, and then we will proceed. Mr. Ed Knight.
Here.
Thank you. Jeff Morris.
Here.
Thank you. Jay White.
Here.
Thank you. And Mr. Dwayne Rogers was not able to join us. We have also a letter of resignation from Larry Sims. He's very sorry to leave the commission. Served, as you all know him, for decades, not only in the industry, but also a long time on the board. So I know he will be missed. So we do have quorum with 3 members here. We've started promptly at 9 o'clock. Our first order of business is the rulemaking hearing that was properly noticed ahead of time, so that we held the meeting at 9 a.m. for that reason. And I'm going to turn it over to our attorney, Anna Matlock, to do the hearing. Thank you.
Good morning. This rulemaking hearing is called to order. My name is Anna Matlock. I serve as Associate General Counsel in the Department of Commerce and Insurance, Division of Regulatory Boards, and I represent the Tennessee Auctioneer Commission. Would the agency representatives who are present introduce themselves for the record?
Jay White.
Jeff
Ed Knight.
Morris.
Ed Knight.
If one of you could press your mic on. Thank you. Roxana Gumucio.
Today is Monday, May 19th, 2025. This rulemaking hearing is taking place pursuant to Tennessee Code Annotated Section 4-5-204 and Conference Room 1B, Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee, and also available by electronic means via Microsoft Teams, which can be located on the program's website at www.tn.gov/regbboards/auctioneers/meetings/.html. On this page, the link for access to the rulemaking hearing via Microsoft Teams can be found in the chart located in the middle of the page in the row with the date 5/19/2025 and the location column under the words Davy Crockett Tower, 500 James Robertson Parkway, Conference Room 1B, Nashville, TN, labeled Connect. The purpose of this rulemaking hearing is to solicit comments on rule amendments to the rules and regulations of the Tennessee Auctioneer Commission. The proposed rules amend certain general licensing and continuing education requirements resulting from the department's review as required by the General Assembly's enactment of Tennessee Code Annotated Section 4-5-213. Most of the rule amendments are clerical and do not impose any additional licensure standards. Specifically, the rule amendments simplify the examination provisions, civil penalty schedule, clarify a portion of the continuing education withdrawal of program approval, and reporting systems requirements. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office for review of legality. If approved, they are filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for 90 days, then end of which time will be the effective date. Please listen carefully. Those members of the public wishing to speak and appearing in person should place their name on the sign-in sheet on the podium to my left. Those members of the public wishing to speak and appearing via Microsoft Teams should place their name in the chat box. Oral comments will only be accepted by those who have written their name on the sign-in sheet and typed their name in the chat box. Is anyone else that desires to offer oral comments but has not written their name on the sign-in sheet or typed their name in the chat box? Seeing that there are none, for those attending this hearing in person, I would call your attention to the table behind me. On this podium, you will find red line copies of the rule amendments addressed in today's rulemaking hearing. The notice of rulemaking hearings included the entire text of the proposed rules and were published on the Tennessee Administrative Register website on January 13th, 2025. Ms. Gamusia, what additional notice was given to the affected individuals or groups?
Thank you. Information regarding the time and location of this hearing was posted to the program's website. Also, we have an email notification system, and that was sent to all licensees or individuals signed up for the programs, and that was sent on January 14th of 2025.
As the agency hears public comment on the proposed rules, I, as moderator, reserve the right to limit such comments if they become repetitive. Please limit your comments accordingly. I will summarize the substance of the proposed rules into the record. Rule 0160-01-.06, examinations, is amended by deleting the text 5 days per week, excluding holidays, provided, however, no examination shall be administered to an applicant who is more than 25 days short of completing the 6 months required for an affiliate auctioneer license. Rule 0160-01-.11, civil penalties, is amended by deleting the text in its entirety and substituting language, specifically deleting the civil penalty schedule and substituting language stating $0 to $1,000 for a separate violation in a statute, rule, or order for licensed activity, and then writing $0 to $2,500 for violations for individuals for unlicensed activity. Rule 0160-01-.14 fees, paragraph 5 is amended by deleting the text in its entirety, removing language from the fee schedule related to reexamination. Rule 0160-01-.23, retirement of license, paragraph 1 is amended by deleting the text accompanied by the license certificate, pocket card. Rule 0160-03.03, basic requirements, paragraph 3, is amended by deleting the text in its entirety and substituting language stating licensees will only receive credit for courses and programs approved by the Commission. Rule 0160-03.06, withdrawal of program approval, is amended by deleting the text of the rule in its entirety and substituting language, specifically paragraph 7. Rule 0160-03.07, control and reporting system, is amended by deleting the text of the rule in its entirety and substituting new language. Ms. Gamusia, were any written comments received by the Commission Office for the rule amendments that were not forwarded to me prior to today's hearing?
No, none.
I received no written comments via email prior to the hearing. I will now solicit comments from individuals present at today's meeting, either in person or via Microsoft Teams. There's nobody here. Okay. Seeing that there are none, this now concludes the comment period for this rulemaking package. Lastly, there are several measures we will need to read into the record as required by TCA Section 4-5-222. All voting will be conducted by roll call. First, I will need a motion to adopt the hearing rules language as presented.
So moved.
Do we have a second?
Second.
Yes.
I'll second it.
Thank you. We have a motion and a second by Jay White. By roll call vote to approve the information as presented by Ms. Matlock. Ed Knight,
Present.
thank you. Jeff Morris,
Yes.
thank you. And Jay White,
Yes.
thank you.
Just to clarify, Mr. Knight, that is a vote in the
Yes,
affirmative.
sorry.
Okay, just wanted to make sure, since quorum's tight here today. Next, I will read the regulatory flexibility addendum. Pursuant to TCA Section 4-5-401 through 4-5-404, prior to initiating the rulemaking process, all agencies shall conduct a rule of whether a proposed rule affects small businesses. Prompt 1. The type or types of small businesses and an identification and estimate of the number of small businesses subject to the rule being proposed that would bear the cost of or directly benefit from the rule being proposed. Response 1. The Commission does not foresee small businesses bearing significant costs to comply with the rule amendments. Although most of the Commission's licensees are small businesses, these rule amendments will apply equally. As the rule amendments impose no new licensure requirements, the cost of compliance, if any, will be minimal. Prompt 2. The projected reporting, record keeping, and other administrative costs required for compliance with the rule being proposed, including the type of professional skills necessary for preparation of the record or report. Response 2. The Commission does not foresee a cost for the administration and enforcement of these rules. Prompt 3. A statement of the probable effect on small businesses and consumers. Response 3. The Commission does not foresee a significant impact on small businesses with these rule amendments. Although most licensees are small businesses, these rule amendments apply to all licensees within the industry equally. Prompt 4. A description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the rule being proposed that may exist, and to what extent the alternative means might be less burdensome to small business. Response 4. The Commission knows of no other less restrictive or burdensome means than through the promulgation of these rules as amended. Prompt 5. A comparison of the rule being proposed with any federal or state counterparts, and Response 5. Rules and regulations for auctioneers vary across the country. However, the rule amendments may be like current or proposed rules and regulations in other state-level regulating jurisdictions. The Commission is unaware of any similar or existing proposed federal rules. Prompt 6. Analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the rule being proposed. Response 6. The Commission does not foresee the need for a possible small business exemption of the requirements in the proposed rules. The rule amendments apply equally to all licensed auctioneers in the industry, regardless of the size of their business. Therefore, the Commission does not see a disparate impact to small businesses. Additionally, the rule amendments provide many clerical updates for simplicity and ease, which may assist small businesses in their daily practices. Therefore, an exemption for small businesses would not be beneficial. I will now need a motion to adopt the regulatory flexibility addendum.
So moved.
Second.
Thank you. We have a motion by Jeff Morris and a second by Jay White by roll call vote to approve the regular flexibility addendum as read by Anna Matlock by roll call vote. Jeff Morris,
Yes.
Ed Knight,
Yes.
and Jay White.
Yes.
Thank you.
I will now read the impact on local government statement pursuant to TCA Section 4-5-228. Response: the Tennessee Auctioneer Commission foresees no impact on any local governments. I will now need a motion to adopt the impact on local government statement.
I'll make the motion.
Second.
Thank you. Jay White, a second by Jeff Morris, by roll call vote to accept the local government statement and the impact it has. Ed White?
Yes.
Thank you. I'm sorry. Ed Knight?
Yes.
Thank you. Jay White?
Yes.
Thank you. And Jeff Morris?
Yes.
Thank you.
Is that-
Thank you,
is that
Anna.
Jeff White or Jeff Knight?
It's okay, we're all friends here today. I will now read the answers to the questions required by the Joint Government Operations Committee. All agencies, upon filing a rule, must also submit the following pursuant to TCA Section 4-5-226I1. A brief summary of the rule and description of all relevant changes and previous regulations effectuated by such rule. Response: the proposed rules amend certain general licensing and continuing education requirements resulting from the Department's review as required by the General Assembly's enactment of Tennessee Code Annotated Section 4-5-213. Most of the rule amendments are clerical and do not impose any additional licensure standards. Specifically, the rule amendments simplify the examination provision and civil penalty schedule, clarify a portion of the continuing education withdrawal of program approval, and reporting system requirements. B, a citation to and brief description of any federal law or regulation or any state law or regulation mandating promulgation of such rule or establishing guidelines relevant thereto. Response, there are no known federal or state laws or regulations mandating the promulgations of these amendments. C, identifications of persons, organizations, corporations, or governmental entities most directly affected by this rule, and whether those persons, organizations, corporations, or governmental entities urge adoption or rejection of this rule. Response, the rule amendments affect current and future licensees as well as applicants. The Commission anticipates proponents of the rule amendments to include current and future licensees, as the amendments positively impact those within the industry. As most of the amendments are clerical in nature, the Commission does not foresee a segment of opponents to the amendments. D, identification of any opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. Response, there are no known opinions of the Attorney General and reporter or any judicial ruling that directly relates to the rule or the necessity to promulgate the rule. E, an estimate of the probable increase or decrease in state and local government revenues and expenditures, if any, resulting from the promulgation of this rule, and assumptions and reasoning upon which the estimate is based. An agency shall not state the fiscal impact is minimal if the fiscal impact is more than 2% of the agency's annual budget or $500,000, whichever is less. Response, there is no foreseeable probable increase or decrease in state and local government revenues and expenditures. F, identification of the appropriate agency representative or representatives possessing substantial knowledge and understanding of the rule. Response, Anna D. Matlock, Associate General Counsel for the Tennessee Auctioneer Commission, Roxana Gamusio, Executive Director for the Tennessee Auctioneer Commission. G, identification of the appropriate agency representative or representatives who will explain the rule at a scheduled meeting of the committees. Response, Anna Matlock and Roxana Gamusio. H, office address, telephone number, and email address of the agency representative or representatives who will explain the rule at a scheduled meeting of the committees. Response, the contact information for Anna Matlock and Roxana Gamusio are listed. I, any additional information relevant to the rule proposed for continuation that the committee requests. Response, not applicable. I will now need a motion to adopt the additional information for the Joint Government Operations Committee.
Make a motion to adopt.
Second.
Thank you. We have a motion by Ed Knight and a second by Jeff Morris. All those in favor by roll call vote. Mr. Ed Knight,
Yes.
Jeff Morris.
Yes.
And Jay White.
Yes.
Thank you.
That concludes this rulemaking hearing. Following the hearing, the rules will be put on rulemaking filing form SS 7039, submitted to the Governor's Office for final review, and then submitted to the Attorney General's Office for review and approval. Once the Attorney General's signature is obtained, these are filed with the Secretary of State and generally become effective 90 days from the date of filing and receiving a positive recommendation from the Joint Government Operations Committee. Thank you for being here today.
Thank you, Anna. Thank you, members. We will now move on to our normal business for the Auctioneer Commission. The notice for this particular meeting was, for May 19, 2025's meeting, was posted to the Commission's website since May 31st of 2024. Additionally, the agenda that you have before you and that was also added to the website has been there since May 12th of 2025. Any comments that the public may have in relation to what's on the agenda or even this hearing could be added, and we would do so to make sure that everyone has an opportunity to speak to the commission. We will do that under new business at the end to make sure if anyone participates last minute on Teams, they also have a chance to voice their concerns. Members, I believe I briefly mentioned our member Larry Sims has turned in his resignation, so we will be having a new appointment fairly soon, but he really wanted to share his appreciation for being on the commission and everything that you all do.
Are we going to send Larry an accommodation letter or something?
Yes, sir. That comes from the governor's office. They've got his resignation letter, so they'll be preparing that for him.
Perfect.
Absolutely.
Well,
Thank
we
you.
appreciate his service, and we hope that he gets better soon.
Thank you so much. I know he will appreciate hearing that and possibly join us virtually when he has a chance. Members, the next item of business is to approve our agenda as you have before you. If there are any changes that you want to make, let me know. Otherwise, I would need a motion and a second to approve the agenda.
Do I hear any discussion or
I move he adopt the agenda as written.
is there a second?
Thank you. Motion by Jeff Morris, and I apologize. Ed, did you second that? Thank you. And a second by Ed. All those in favor of approving as presented, please say aye.
Aye.
Any opposed? Thank you, members. Hearing none. We will proceed on your iPads. We have the information for the budget. This is as of March of 20.
Excuse me, we need to approve
Oh,
the
your
meeting.
minutes. I'm sorry. You're right. I'm jumping ahead. You have before you the minutes from the February 24th, 2025 meeting. Those were also emailed to everyone. If you see any changes that are needed, please let me know. Otherwise, I would need a motion to approve those minutes.
I move to adopt as written.
Thank you.
Second.
Thank you. We have a motion by Jeff Morris, a second by Ed Knight. All those in favor, please say aye.
Aye.
Any opposed? Hearing none, thank you. Okay, now we are at the budget. That is on page 7 on your iPads. These numbers are as of March 2025. They reflect a year-to-date surplus of $8,175. And so that leaves the reserve balance at $525,741. The educational fund is at $182,654. We have one invoice that is going to hit probably here soon regarding the last particular continuing education session we paid for, but I think that fund now is back to a comfortable stage above. As you know, it has to be above $150,000 at all times. There are no questions regarding the budget. We will have, of course, the year closes for us June 30th, so for the August meeting, we won't have final numbers, but at least we'll have an idea of where we'll end for the year. On your iPads on page 8, we have before you the 2026 meeting dates. As you can see, our meetings have been moved to 10:30, which, thanks to your ideas and thoughts, I think is going to be a great thing for each of you as well as for the commission's budget. So if you see any changes, please let me know. They're at the same that Monday, like we've always respected the middle of the month, and 10:30 as opposed to 9. So if there are any changes, let me know. Otherwise, we would need a motion, and then we would proceed with updating our website.
Do I hear a motion?
Second.
I make a motion, we
Oh,
approve
sorry.
the dates as
He made a motion.
presented.
Commission meetings, all to be held at 10:30. Are there, is everyone in agreement?
Yes.
Any opposed? Thank you, members. We will update our website here by tomorrow for sure. I will go ahead and turn over on your page 9. You start with the legal report for this month, and so I'll turn it over to Ms. Cooper, please. Thank you.
Good morning, members of the commission. The legal report is a little bit longer than usual. I can take them one by one, or we can do them all in a bunch, if whatever you prefer. One at a time? Okay. The first complaint you have regards a complainant who alleged he was the winning bidder for a vehicle. It turns out the vehicle that he was bidding on had been his vehicle, had been repossessed. He alleges that the respondent withdrew it from the lot illegally and would not let him pay for it after he was the winning bidder. The respondent gave a detailed response explaining that the terms of the sale required payment by 2 p.m., that the complainant/bidder did not make payment by 2 p.m., that once payment is not made per the terms of the sale, they try to obtain payment through the credit card that's on file. They attempted to do that, the credit card was declined, and so he was banned from the subsequent auction where they had moved the vehicle to the next day. I didn't see any grounds for a violation, and so I recommend dismissal.
I hear a motion.
I got a question on
Yes.
this one. It says, at the top, am I reading this correctly? He's licensed in 98 and expires in 20.
Yes, sir. This is an auction pursuant to it's a municipality, one of their police departments, so he is exempt. Yes, sir.
Do I hear a motion?
I move that we accept the legal counsel's recommendation of dismissing.
A second.
Second.
All those in favor?
Aye.
Aye.
Thank you. The next complaint on your report alleges unlicensed activity by a respondent and their spouse. The respondent did provide a response that said that they had been apprenticing under a licensed auctioneer for almost 4 years and had been told by that licensee that they didn't need to have a license yet for online auctions. The respondent did reach out and request information on how to become licensed. I directed them to the proper person in the program to assist them with that, but there was evidence of unlicensed activity at the time, despite the bad information from the person that they were apprenticing with. So I recommended a $250 civil penalty for unlicensed activity.
When did that case get settled and online auctions came under our purview? Do we know that date?
November, I want to say.
The case is still ongoing. It's on appeal at the Sixth Circuit.
Okay, but online auctions now come under our purview, effective as of what date, do we know?
I'm not sure. I know, I think I mentioned it at the meeting in November, possibly. We requested information from the AG's office, and they gave us permission to move forward with regulating.
Okay. So this came in after that
Yes.
date?
No?
It did. It was just after that meeting that this complaint was opened.
Yes.
Which is why I felt like a minimum civil penalty would be appropriate.
Did the activity happen after that date?
Yes, sir.
Okay. Well, we got to make a statement at some point in time, so I think I would like to go along with your recommendation that we at least start assessing some penalties, and I don't think the 250 is onerous, so I would make a motion that we agree with your assessment of the case and adopt your penalty.
Is there a second?
Second.
All those in favor?
Aye.
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 Thank you. The next complaint was from a purchaser that had purchased numerous items from this respondent's auctions over the course of several months, and then came back and alleged that the respondent was either misrepresenting the value of the items or was intentionally misleading potential bidders to the condition of the items. The respondent denied misleading anyone, that they had ample opportunity to review the items before they bid, and they provided all of their timestamps and records, advised that they, at the beginning of every auction, they say as is. They weren't really sure why the complainant came back to the auctions if they were not getting what they felt that was their money worth, and so I just didn't believe there's a violation to be found here and recommend dismissal.
Well, you're always going to have those people. We've all had them at our auctions, I can tell you that, you know, and that's why my standard answer to any question is I don't know. So, so I agree with your assessment. I think make a motion we dismiss this case.
Is there a second?
Second.
All those in favor?
Aye.
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 The next complaint was a complainant alleging that the respondent auctioneer had had their items in storage since 2020 and refused to sell them, and sell all of them, that there had been at least one auction where some items were sold and the respondent felt like, the complainant felt like they had withheld $169 payment to them for the items sold in a previous auction. I had to do a little digging here, and I'm still not sure whether this auction that this complainant is concerned about even occurred in the state of Tennessee. The respondent is licensed in a border state, and assured me they tried to work with the complainant. They went ahead and sent them the $169 just to take care of that part of it. And they are trying to work with this complainant to get the remaining of their items out of storage, because quite frankly, the respondent doesn't want them either. So I didn't see that there was any violation here and recommend dismissal.
Do I hear?
It makes a motion to accept dismissal.
Second.
All those in favor?
Aye.
Aye.
Thank you. The next complaint, a complainant alleged that the respondent was basically in violation of your advertising rules that require that the respondent's name and license number are provided on all of the advertising. What the complainant sent in was only a partial screenshot of what of the website for the auction. When I went and looked at it, you had to scroll to the bottom of the website, but all of that information was there as required, and so I recommended dismissal.
Is it the requirement is it one page in from
Do
social
we have the
media?
one-click rule? I don't think we do. No, sir.
No.
It just has to
Has
be.
to be displayed, correct?
Yes, sir.
Okay.
And this wasn't on a separate page. It was on the main page. You just had to go to the bottom.
Make a motion, we agree with your recommendation to dismiss this case.
Is there a second?
Second.
All those in favor?
Aye.
Aye.
The next case is probably the most difficult one, and so I recommended discussing this one to get your ideas of if you see a violation here. The complainant is the owner of a restaurant and was the winning bidder for a mixer. You see there that it was advertised as brand new with 6 attachments. The winning bid was almost $9,000. When the mixer was delivered to the complainant's restaurant, they were not present for the delivery. It was a manager. The manager accepted delivery. It was put in storage for a little bit until they needed it. So there was at least 2 or 3 months here between when it was delivered and when it was pulled out of storage for use because their other mixer broke. When the complainant was using the mixer, it worked for a little while and then it too broke. So they called the company that made the mixer and asked for them to come out and fix it. The technician got out there. The complainant said, "Is it still under warranty? Because it's brand new. We've only had it a couple of months." And at that point, the technician advised them that it was a 24-year-old mixer. It was not brand new, but it had never been used. The respondent, and I provided it verbatim there, their statement said that brand new refers to items that have never been used and retain their original packaging or protective coverings. To make a long story short, the respondent said that they were the ones that removed the packaging so that they could take the pictures for the website advertising the auction, but that it came in the original packaging when they got it and advertised it for sale. And that to them, because it had never been used and was still in its original packaging, that it should be considered brand new. The complainant did not like that response and said that a 24-year-old mixer is not brand new, regardless of whether it had been used before or not, and that the respondent knew that it was not a brand new, made this year mixer when they put it up for auction. And so I defer to you all if you would deem that to be misrepresenting the item.
This sounds like a civil case to me. It's not I don't think this is an auctioneer rules and regulations or licensing issue. I think they'll take this up in small claims court. I would not have done what that auctioneer did. I wouldn't say it was brand new. It's 24 years old, even though it was in the original packaging. You can say it's never used, but you can't ever say brand new, and that's a big difference. So I would recommend that we dismiss the case and then we advise the complainant to file a civil case against the auctioneer. I mean, what do you guys think?
Yeah, I agree with that. I mean, you run into that. He could have used a little different wording. The auctioneer could, but the buyer as well probably had a serial number.
It did, yes, sir. And to your point, the respondent pointed that out. That
Yeah.
said the serial number was
I mean,
available.
they got to do a
search.
little bit of due diligence. I get it. They're excited. They get it. Great value on a brand new piece. I'm sure he's making maybe half price. I've never sold
mixers.
Mixers, you know, but you know, both of them could be at fault, but I think in civil, I don't think they're breaking any auction laws.
Your mic, if you don't mind. Thank you, Jay.
Oh, I concur. You know, in my opinion, I'm not an attorney or a judge, but I mean, I think this is more of a civil matter than it is something that we need to take up. But, you know, I believe there's some liability here that needs to be, I do believe that this consumer needs to carry this a little further if this is the case.
Well, I'll make a motion that we dismiss it and advise the complainant to file a civil case if he'd like to.
Is there a second?
Second.
All those in favor?
Aye.
Thank you. The last complaint, excuse me. Last complaint before you today, the complainant was the winning bidder for a commercial property. The respondent was the auctioneer listing agent. The complainant alleged that the closing could not take place due to an incorrect survey of the property and that the respondent asked the complainant to sign an extension for a new survey. The complainant alleged they declined to do so and just wanted their earnest money back. The respondent, of course, had a bit of a different take on what happened, said that they tried repeatedly to work with the complainant to get the closing done, that when they could not get the closing done and the complainant demanded their money back, that the seller didn't want to give the earnest money back. And so what you do at that point is you interplead the funds with the court. And that's what they did. They then tried to serve the complainant with the court documents to have the argument before the judge as to whether or not the earnest money should go back. And it took several months for them to get the complainant served for that. There has not yet been a decision regarding the earnest money as of the time that they filed this complaint. But I did not find sufficient evidence of any wrongdoing on the part of the respondent. They tried to do what they were required to do, and it's just taking longer than it should have.
That's a perfect case for an interpleader. Though this is not a jurisdiction of this commission, I move that we dismiss this case.
Is there a second?
Second.
All those in favor?
Aye.
Thank you, members of the commission. That's my legal report. I do have one other issue. There was supposed to be an administrative hearing today at the request of the respondent. It was continued to your next meeting, which is August 18th, I believe. In the interim, the administrative law judge that was overseeing the matter asked if we would consider mediation. That is not something I have done either with this commission or with the other commission that I work with, but I do believe that it could be fruitful in this instance. If we are able to reach a decision, it would mean that we would not have a hearing on the 18th. However, you all would have to agree to delegate to the director the authority to approve that settlement on your behalf. And so I'm asking you today, should we make a settlement that the director is happy with and believes is in the best interest of the commission, that you allow her to do that?
It'd be fine with me.
Do we need a motion for that?
Yes, sir.
Do we have a motion for that? I'll make the motion. Can I make the motion, Jim? I'll make the motion to give you the right to act on our behalf on this.
Second.
All those in favor?
Aye.
Thank you.
Thank you all.
Is that all you? Thank you very much, members. And that is all that I have. Any other business that the commission would like to address?
The only thing I would bring up, typically we, either our February or this meeting, we get approval to do the NAA convention expenses. And usually Ed and I go, and I don't know if we could bring that up today and vote on that.
Yeah, I don't have any information on it to present. If you know the dates, absolutely, we can vote on it or any information.
I can get them for you.
Yeah. And I don't think that the dates necessarily matter. If the commission is inclined for 2 members to go, I think that's what we did last year and we've done previously. We can vote on it and put through the justification based on the information that the conference has out there.
Well, if Jay will make that motion, since it'd be self-serving if I did it.
I'll make the motion that we send 2 members to the national convention.
July 15th? Okay.
And I'll
Anna-
second it.
And Jeff second. So Anna beat us to the date. She said it's July 15th through the 19th, so it would be before our August meeting. Thank
Yeah,
you,
it
Jeff,
ends
for
on my
bringing that up.
birthday.
All those in favor?
Aye.
Aye.
Thank you. And we will look at that justification if you'll both make your hotel reservations and
We'll
registrations.
take care of it.
I'll reach each of you via email. Thank you for bringing that
I,
up.
I got approved last year, and didn't go, so we saved all that money
We
last
saved-
year.
We saved it, yes, yes. I don't have any other commission business. I don't see anyone on the call. I think Dana would let us know if any hands were raised. So at this time is when we would make sure that anybody participating in person or remotely has a minute to address the commission members, but hearing none, I would entertain a motion for us to adjourn.
So moved.
Second.
We have a motion and a second to adjourn the meeting, and it is 9:40, I believe. Thank
Yeah.
you, members, for everything.
You're
All right.
welcome. Thank you.
Thank you.